Welcome! NB Law would like to guide you through the 5 stages of a traditional merger and acquisition transaction. Seller's preparation stage, letter of intent stage, due diligence and purchase agreement negotiation stage, signing and closing stage, and post-closing stage. Stage 1. Seller prepares for a sale. Seller must first prepare the business to be sold at maximum value. First, seller undergoes a spring cleaning, where it organizes and updates as needed its various contracts and records. Next, seller or its financial advisors prepare financial statements and projections and develop a sales and marketing strategy. Seller may engage an investment banker to assist in identifying and negotiating with prospective buyers. Seller also prepares a form of confidentiality agreement, often called the non-disclosure agreement, for prospective buyers to sign before receiving information about the business. Stage 2. Letter of intent. During this early stage of negotiations, the senior management and advisory teams discuss general terms of a deal, focusing primarily on purchase price range. Once a general deal has been agreed to, buyer and seller negotiate and execute a non-binding letter of intent containing detailed deal terms, including purchase price, method of payment, transaction structure, exclusivity, and conditions to closing. Stage 3. Due diligence and purchase agreement negotiations. After the letter of intent is signed, buyer and its advisors conduct financial, operational, and legal due diligence. This entails reviewing seller's contracts, organizational documents, financial statements, and other documents and materials relating to the business. Buyer may also meet with seller's key personnel to ensure that employees will continue on after closing and will fit within buyer's business culture. One of the main goals of due diligence is to confirm or refute buyer's assumptions regarding the value of the business and to discover any hidden issues or potential liabilities that could negatively affect value. While due diligence is ongoing, buyer and seller negotiate the purchase agreement and related ancillary documents. Deal terms agreed to in the letter of intent may need to be renegotiated based on due diligence findings. During this stage, seller must also ensure that the transaction does not distract from running the business, as buyer will continue to closely monitor seller's financial performance. Stage 4. Signing and closing. In a majority of transactions, buyer and seller sign the purchase agreement and close on the transaction simultaneously. In more complicated deals, closing may not occur until some period of time after the purchase agreement is signed, for reasons including the need for regulatory filings, third-party consents and approvals, or buyer financing. Stage 5. Post-closing. Buyer and seller's relationship usually continues for some time post-closing. Among other things, there may be a purchase price adjustment. Seller may be entitled to an earn-out payment or have confidentiality, non-competition, and non-solicitation obligations, and buyer usually has continuing indemnification rights. Thank you for joining us for the stages of an M&A transaction. For more information on how NB Law can help with your deal, visit www.nemphosbraue.com or call 410-321-8200.